Good morning. Still a little bit of the morning left here. This is the time set for oral argument in LUBA number 2026-029, Schirmer Consulting versus the City of Eugene. I'm Board Chair Zamudio. Board members Wilson and Basham are also present. Please keep your audio muted when you're not speaking. That will help with our recording. And this oral argument is being recorded and live streamed. Pending matters that we have are the city's motion to dismiss, responses to that motion, and a motion to strike, and a motion to take evidence that are pending. We are planning to suspend this appeal so that we can resolve that jurisdictional issue, recognizing that there's some time for the city to respond to those motions that we've recently received. And so we will be issuing an order suspending this appeal so that we can resolve that jurisdictional issue, which we may do together with the merits, depending on how we land with that. So just wanted to let you know, expect that order coming out. Oral argument is a total of 30 minutes. Petitioner, you have 15 minutes and may reserve up to 5 minutes for rebuttal. Would you like to reserve any time?
5 minutes, please.
Okay. I will keep track of time here and ask that you keep track of your own time also. And respondent, you will have a total of 15 minutes for your response also. So with that, petitioner, please state your name for the record and begin.
Thank you, members of the board. I'm Bill Close on behalf of the petitioner. It's always nice to be back. This started out as a humble little single issue, a case that then got consumed in a big dust up over jurisdiction. Things are never as simple as you think they're going to be. As for the jurisdictional point, I kind of did things backwards inadvertently. I think the most significant filing I made on jurisdiction was my short supplemental memo on jurisdiction, wherein I just looked at language that was on the face of the city's form for filing for a lot validation. And we all know lot validations are those miracles where you start with the benefit of the statute, you start with an illegal lot and you come out the back end of the pipe with a validated legal lot. And the point is you have to go into the pipe, you have to go into that process with an illegal lot. And the city's form for filing for a lot validation says on its first of 3 pages, by the way, folks, you have to start with an illegal lot. And one of the ways of proving up on an illegal lot is you can go get a legal lot verification from the city and come out of that process with a determination that you don't have a legal lot. And that qualifies you to then file for one of our lot validations. Now, the city's position, if I understand it correctly, in the jurisdictional briefing, is that the lot validation process at the city does result in a land use decision, but the legal lot verification process at the city does not result in a land use decision. It is just an informal discussion between friendly staff and a curious property owner, which is then reduced to a memo, which looks a lot like a land use decision. So the city's drawn that distinction. The city's saying these are really 2 different things. Legal lot verification, not a land use decision. Get out of here. You don't belong to LUBA. Lot validation, now that's a land use decision. The point I make in my supplemental memo is, which is actually shorter than my discussion here. The point I make in my supplemental memo is that there's no difference between the legal lot verification process and documents and the lot validation process and documents. Neither one of those processes is explicitly provided for in the code. And yet they both have application forms. They both require fees. They both result in decisions by the city. We'll call it a memo, call it a decision. Both of them apply the law. And so our point is that in the supplemental memo is that right there on the face of the lot validation form, the city is basically conceding that the legal lot verification process and the thing that you get at the end of that process, whether it's call it a memo, call it a spear, call it an arrow, the thing you get at the end of that process is something that you can take into as a starting point of the lot validation process. That makes it a land use decision. Now, the bulk of our briefing on the jurisdictional matter, basically all of our evidence, 90% of our evidence that we submitted in support of jurisdiction, consists of documentation on three other applications, three other decisions. One was a property line adjustment. One was a standard partition. And the third was a middle housing land division. Now, each of those applications, as we documented the code, requires you have a legal lot to start with. None of those decisions that we've given you, partition, property line adjustment, or middle housing land division, none of those actual decisions addresses the question of whether or not the applicant is starting with a legal lot. And the reason for that is, logically, we've also given you, for each of those three little mini case studies, a copy of the legal lot verification that the property owner, the applicant.
Sorry, Mr. Close. Were those legal lot verifications that you put in the motion to take out, were those also in the record for those three cases? I couldn't quite tell.
No. In one case, I believe it was the property line adjustment. Could be wrong. The hard copy of the city's property line adjustment decision references at the top on the front page other related decisions. And that listing of other related decisions identifies the legal lot verification associated with that property that came before.
So
the other two
relying on that.
Pardon?
It's clear that it's relying on that legal lot verification.
Well, I don't know that. It's listing it as a, you really can't tell. It's listing the legal lot verification as a decision with a number that's related. Now, my point in the kind of extensive briefing on that is that if the city's making a decision on a partition or a property line adjustment or a middle housing land division, and the code says, all y'all got to start with a legal lot. And we've cited the code that says that in each instance. And then you look at the actual decision, the legal lot verification, partition, property line adjustment, or middle housing land division. You look at the decision, and it doesn't address the standard. It doesn't make a decision internally as to whether or not these folks started with a legal lot. Then
it's kind of weird. Both of those, that's not actually an approval criterion. If you look at the approval criteria, like one of them, it's in the purpose statement. The other one in the application submittal requirement. So does that change anything?
I don't think it changes a darn thing. I mean, you can't get through the wickets. You can't. The city is not, whether the requirement for having a legal lot is stated in the purpose statement or an information requirement or a standard. The gist of the code is you can't get a partition unless you start with a legal lot. You can't get a middle housing land division unless you start with a legal lot. That's it. Good luck trying. So I don't think we want to put formatting over substance. You have to start with, you have to be in good stead with a legal lot status in order to start the process. And if the city is correct that all of these legal lot verifications with all the forms and the fees and the formalities really just result in an informal discussion, documentation of informal discussion with the city staff, then you would expect that the city, in conjunction with making the property line adjustment approval or partition, would be making a finding that, yes, this is a legal lot, we can go further. And they're not saying that anywhere. So what? Either they're relying on the legal lot verification, which came before, that's the efficient way to do it, or they're just making all these decisions with a giant glaring hole in each one of them because they are not making the legal lot finding from the get-go. That's about what I can say on that. So that's a lot on jurisdiction. I reviewed the merits of our brief on this. I have so little to add to the merits of the issue here. I guess I would just pass along to you a question that my client passed along to me when all this got started. He said to me, he said, so Bill, he says, if the city's taking the position that they're taking here, then what if I buy a fully platted, undeveloped subdivision with 20 lots in it that are all still in the same ownership? You know, a plat that was recorded in the mid-50s or something. I buy the whole thing. And the conveyance to me, the deed conveying that entire undeveloped subdivision to me, could look exactly like the conveyance language that the city has applied here. You know, it could just and just plug in the 20 lots here instead of the north 110 feet of lots 12 and 13 in block blah blah blah. The same conveyance language could be used, and if the city's right in the context of my application now, then the city's position would be that all 20 of those lots get consolidated with that deed and the subdivision goes away. And I said, that's a really good question. I said, I'm sure the city will jump at an opportunity to answer that during the oral argument. So I leave that question on the table. That's about it for my opening statement. Thank you.
So to make sure I understand your argument, under ORS 92.017, if the 1959 deed, if it had, I think you're arguing that it could have merged if it had wanted to. Like if it's been very specific and said, we started with 3 legal lots, we've only got 1 now, woe be to any man or woman who says otherwise, that would have merged them, and 92.017 wouldn't undo that. If I understand what you're saying is like the 1959 deed did not do that.
The 1959 did not do that.
And so if the deed is, under our case law, if the deed is silent about merger, basically the default position is it does not merge them. Is that
That's right?
Our assumption?
That's right.
All right, thank you.
Okay, no further questions from the board. We will turn to the city for their argument.
Good morning. May it please the board, Lauren Summers, representing the city of Eugene. The city does intend to file a response and objections to petitioner's motion to strike and motion to take evidence not in the record related to jurisdiction. So just to let you know, that will be coming. And I'll hit a couple of petitioner's points before I launch into the meat of my argument. But in terms of petitioner's discussion of the supplemental memo or supplemental response to the city's motion to dismiss and focus on the language on the lot validation form. First, I'd like to point out that the lot validation form is currently outside the record. That's part of petitioner's motion to take evidence. But then I would just draw the board's attention to the language in the lot validation form, application form, requires evidence of an illegal lot because you can't validate a lot under ORS 92-176 unless it is not a lawfully established unit of land. That is part of the statutory requirements. The legal lot verification can act as evidence that a lot was not legally established, but so could a lot of other things, deed records, other things. And in the motion, petitioner kind of makes a lot of the fact that there's no process or criteria for lot validation in the Eugene code, just as there's no process or criteria for a legal lot verification. But I would point the board to the process and criteria in the statute for a lot validation. The city hasn't incorporated those into the Eugene code, but they do exist. And the ORS 92-176 provides that a decision on a lot validation is a permit decision as defined in ORS 227-160. Compare that to the legal lot verification process, which does not, there's no process in statute, there's no process in the city code, there's no approval criteria in statute or the city code, and there's no appeal process for a lot verification decisions. So they are different. Similarly, when petitioner points to those three kind of sets of legal lot verifications and land use decisions that are also outside the record and are part of petitioner's motion to take evidence not in the record. Again, the petitioner is correct that the land use decisions, the partition decision, the middle housing land division, et cetera, do require that the subject property be a legal lot as defined in the Eugene code. But again, a legal lot verification is one way, one kind of set of evidence to show that the subject property is a legal lot, but you could also submit a subdivision plat or a partition plat or a lot validation. It's not a requirement to have a legal lot verification prior to a land use decision. And applicant doesn't point, or I'm sorry, petitioner doesn't point to any evidence or any board decisions that indicate that evidence submitted in support of a land use application automatically becomes a land use application. Okay, so.
I'll jump in quick. So
yeah.
in your motion, you say that this is just a preliminary decision. To me, it sort of comes down to whether this is a final decision or not.
Yep.
And you cite the Davis, I think Davis case.
Yes.
And then you say this is just like that, basically.
Yep.
The Davis case was pretty clear from the language that it was definitely preliminary. And then you say this is like this, and that's what Mr. Close is moving to strike. Is there anything you can point to besides you telling us that it's preliminary, anything in the code or your process or anything that would make this like Davis?
Sure. Thank you for that question. So it is the city's position that this is exactly like Davis, except for the fact that the decision in Davis did include language on the face of the decision that said, hey, this is a preliminary decision. But every other aspect of Davis is reflected in what's happening here, in the process here. And indeed, actually, in Davis, the county specifically identified the legal lot verification as a quote land use application, which the city does not. But what the board in Davis looked at were several things. That the county code did not contain any standards for evaluation of a legal lot verification. The city code doesn't either. The county code, the only thing the county code contained was a definition of a legal lot, just like the city code. The county code did not contain a process for making final binding evaluations in terms of the legality of a lot, nor does the city code. And the board held in Davis that the legal lot verification approves nothing, that it was just a review of land records to determine whether those records indicate that the lot was legally created. The city's process is the same in all material respects, except that express kind of preliminary language, but it's the verification. It just simply isn't a final land use decision. There are no approval criteria. There's no process. There's no opportunity for appeal. It's not, it is a staff review of records related to a particular piece of property to determine whether that property meets the definition of legal lot in the Eugene code.
So it's almost a glorified pre-app for your purposes.
Yeah, I think the city would take that position. Yes.
Is there a city code process for a lot validation? I think your motion cites to the statute. Does the code also contain a lot validation?
No, the city has not incorporated the statutory requirements into the code. The statute itself provides that a city or county may approve an application to validate a unit of land that was created by sale that did not comply with the applicable criteria for creation of a unit of land if the unit of land is not a lawfully established unit of land and could have complied with the applicable criteria when the unit of land was sold. And then
That apply if there wasn't, if there's not an assertion that, that you're not trying to validate what otherwise would be an illegal lot or something that was not lawfully established, but you're trying to determine how many lots you have. Your position is there's just no process for that. There's no formal process for that.
that's correct, other than as part of a formal land use application process. So if you come in for a middle housing land division or a partition or subdivision that requires that the subject property to begin with is a legal lot, and staff says we don't think it is as part of that land use decision, that certainly would be appealable. Or if staff says we do think it is, and as part of that land use decision, someone else could appeal the land use decision.
Okay, thank you.
In terms of Mr. Close's question from his client about, well, what if I bought an undeveloped subdivision today? And would the city just assume that if I own the entire subdivision, I own all the lots in the subdivision, would the city just assume that it's one legal lot? The answer is no, because of ORS 92.017, which took effect in 1985. So from 1985 onward, 92.017 says that a legally created lot stays a legally created lot unless the lot lines are vacated or there's a future, or it's further divided via another subdivision or partition. But what we're talking about is land transfers that all happened prior to 1985. And in fact, the board member Wilson, as you pointed out, the operative transfer that the city is focusing on is in 1959. So it was both prior to 1962, which is when the local partition and subdivision regulations were adopted and deed transfers could still function. And prior to 1985, significantly prior to 1985. So ORS 92.017 did not exist at the time and didn't operate to kind of freeze in time lots created by deed. It appears to be petitioner's position that anytime a lot was created by a deed, it's frozen in time, regardless of whether that happened prior to or post 1985. It's the city's position that ORS 92.017 is not retrospective in effect, and petitioner hasn't pointed to any evidence or text or context or legislative history that would indicate that it was intended to be retrospective. So the 1959 deed transfer operated to create a single lot, and that same lot has been passed on subsequently since 1959.
So getting back to Mr. Close's question, so say, I think the original lots here were created like in the, like pre-World War I, right? And say they'd all just stayed together miraculously for 50 years or 40 years. And then they got transferred in 1959 with a deed just like this, that just described, the boundaries and didn't say, would the city, seems to be consistent, the city would say, nope, you just got one lot now. Am I missing something now?
No, I think that's right, if it was transferred in 1959. But I understood Mr. Close's question to be if it was transferred today. And that would be a different story because of ORS 92.017.
Okay, thanks.
In terms of the substance of the appeal, well, I guess we've really talked about that. Yeah, I think those are the points that the city was really hoping to make. So unless the board has any further questions that I can answer, the board would ask the city to, or the city would ask the board to grant the city's motion to dismiss, or if the board does find it has jurisdiction, to affirm the city's decision. Thank you.
So Mr. Close's position is that if the deed is silent to merger, the default position is that it doesn't merge. Do you A, disagree with that, or B, think the deed is not silent as to merger?
In this case, I think the context of the deed indicates that those lots were intended to be consolidated the way that the various deed transfers happened. And that the deed transfers were kind of the functional equivalent of a property line adjustment, that it was the same owner buying and consolidating a piece of property. And then when that was consolidated, it continued to be transferred as the same piece of property using the same legal description in the future. It is true that the legal descriptions refer back to the original lots. And this is speculation, but I assume it's because it was easy, and no survey would be required. So yes, in this case, because of the external context, it's the city's position that those lots did merge.
Okay. And then last question. If we do agree with petitioner that it's a land use decision and that the lots didn't merge, what should our disposition be? Do we remand? Do we reverse? Do we order you to approve 3 lots? And I'll ask petitioner this too, but what would the city's position be on that?
So I believe petitioner is asking for reversal and remand with direction to the city to say, hey, this is 3 lots, not 1. I think, you know, it's the city always would prefer remand over reversal, but in this case, you know, if the board completely agrees with petitioner that this is a decision the board has jurisdiction over and the city got it wrong, I'm not really sure what other findings the city could make if the board is in agreement that in fact it should be 3 lots instead of 1. It seems to be pretty just a dichotomy here, one way or the other. But the city does include in its briefing, in the event of a reversal, the reason that petitioner would not be entitled to attorney fees.
Okay, thank you.
Okay, we are at time there for the city, so we will return to Mr. Close for rebuttal, and you have I think 2.5 minutes for your rebuttal. So go ahead. Oh no, 3.5 minutes, sorry.
Yeah, and you're still muted.
You're still muted, sir. Council Close, you're still muted. I think we missed something funny also, so if you could come off mute and share with us what you said, please.
I'm sorry, I have my microphone off. It's probably just as well. You just wonder where the time goes when you're having such a good time. There's no mention in our brief of attorney's fees. That's only in the city's brief. Referee Wilson got it right. My question about merger of the vacant subdivision and single ownership, relates back to pre-85 or pre-62. It relates back to 59 when the city says my client's property got merged, and you put your finger on it, and city says, yeah, it all goes away. I just want you all to appreciate too that, and I get a little bit of heartburn every time I say this. I was the attorney that lost Davis. I mean, how's that for an item for my memorial service? That was very disappointing. But I understand it. Yeah, I mean, there it is, big, bold letters on the bottom of that legal lot determination that says, hey, this is preliminary. Go apply for something if you want a final decision. We don't have that here. I guess not to belabor the point, but there are standards to apply here. The definition of legal lot boils down to a standard. You know, you need to look at the deeds and figure out what they say. That's pretty standardly. And there is no, to go back to the question of, is there a process in the code for lot validation? There's not. And yeah, sure, there's one in the statute, but I'm not sure the statute language is particularly relevant to whether the code honors a process or enough of a process, or everything but a formal process to create a land use decision. This is really about the code. It's not about the statute. And when you just look at the code's treatment of legal lot verification and lot validation, those things are treated like siblings, twins in the city's code. I think that's really about it. Thank you very much.
I would like to reiterate Board Member Wilson's question about the proper disposition. Give us your best argument, what we should do.
Our best argument is it really boils down to a question of law applying the statute, and Luke can do that as well as the city, and let's be efficient about it. I appreciate the city not wanting to have this land on them again.
So I would translate to that you're asking for a reversal.
That's right. That's
Okay.
right. Yeah, I think we're pretty clear as somewhere in our briefing that that's exactly what we want. Okay. So I think the city and I are together on that.
Okay. No further questions from the board. Thank you. That will conclude oral argument. The statutory due date for our decision in this appeal is July 30th. Oh, don't need to say any of that because I already said we're going to suspend this case. So look for that order, and we will look for the response that the city has indicated that they're intending to file with us. So thank you.
I think it's due this week, Thursday.
All right. We'll see that when it gets here.